Hi, my name is Mark Egan. I'm an immigration attorney with Gunderson, Denton, and Peterson in Mesa, Arizona. Recently, on November 20th, 2014, President Obama announced some of the most sweeping immigration policy changes that I've seen in my entire 20-year career in immigration. These are known as executive action for improving the immigration system. As many people know, our immigration system doesn't work very well. It's got lots of problems. And the solutions don't seem to be forthcoming from the Congress, so the President sort of took matters into his own hands and used his authority as the executive officer to choose how the Immigration Service will allocate its resources in trying to protect the United States, find people that are dangerous to the community or dangerous to the country, and deport those people, and at the same time providing the necessary services to people who are trying to do things the right way. So what is executive action? Basically, executive action is an enforcement priority decision or program that the President has put together along with guidance from his legal advisors in the Immigration Service. The main focus is simply on who is going to be the main priority of all of their efforts, specifically regarding catching and deporting people who are in the country illegally or who may have entered illegally but since then have committed crimes or fallen out of legal status. It's well known that there are probably over 10 million people in the United States without proper legal documentation. Most of those people came here primarily for economic purposes. They were not able to support their families on the economies of the countries where they came from. There were plenty of employment opportunities in the United States where people needed workers, and so supply and demand, they've come here to work and to support their families. Unfortunately, there are always bad apples in the bunch, and there are also people in those undocumented millions who are not so interested in doing things the right way and are willing to commit crimes, smuggle drugs, smuggle human beings, and do other things which we cannot tolerate. The executive action policy decision basically decided that because the Immigration Service has limited resources, limited manpower, limited money, limited time to go around checking on things and people, they are prioritizing those people who are in the country without legal status who actually pose a threat to the security of the United States or a threat to the safety of the community and other people. What this means is that less efforts will be dedicated to essentially chasing after people who are hardworking dishwashers, landscapers, engineers, whatever, that don't happen to have legal status, and use those resources instead to do the much more difficult work of tracking down criminals, people that are participating in criminal gangs, terrorists, and potential terrorists, and true threats to the safety and the security of the country. The program that was announced on November 20th covered about 10 different areas. But as an immigration attorney, there are 3 areas that are probably going to generate the most interest and affect the most lives directly. And I will cover those in more depth at a later time. But very quickly, the 10 areas that are targeted in the policy announcement. Number 1 is to strengthen the border, to change some of the ways in which we do business when that business is guarding the borders of the U.S. and ensuring that only people that have been given permission come in. Second priority is to revise the deportation or removal procedures such that spaces on the docket of the courts and judges that process removal cases, basically immigration deportation hearings, are not clogged with low priority people, low priority cases, meaning there are a lot of dangerous criminals and others that will probably wait, even though they've already been apprehended, they will not have a hearing that will result in their ultimate deportation for 2 or 3 years, sometimes even longer. If someone is apprehended today, it could be another year before they have the first hearing, which basically is just going to set the calendar for the rest of the proceedings, and those additional proceedings might be set another year out because there are just so many people, so many cases that are being processed through the immigration judicial system. What this new program will do basically is give those who are low priority, low risk, low threats, who are working and contributing to the community, who do not have serious criminal records, no indication that they are a threat, give them the permission to remain without fear of deportation for 3 years. That permission may be renewed at the end of that 3 years if the program still suits the needs of the United States and quite simply the interests of the executive, the president, whoever that will happen to be. So it is by no means an amnesty, a blanket waiver. It basically means you are not the people that we need to get rid of right now, and we are going to focus our efforts somewhere else. Our community is safer if you have some sort of legal status so that you can come out of the shadows, work and live like a normal human being, and will be less likely to fall prey to criminals or to resort to crime because you're not allowed to do honest work. So that was point number 2, reordering the priorities for our deportation legal system. Number 3 is ending a program called Secure Communities. This is a program that was started several years back. On the surface, it was supposed to gain the support and benefit the local community law enforcement agencies. In actual practice, it has proved problematic and become very controversial. The new executive action proposes to replace the Secure Communities program with a new program called Priority Enforcement. We don't yet know exactly what that's going to be, but that's point number 3. Point number 4, and this is where we begin the actions that will actually impact a lot of people here and will enable and facilitate this reordering of priorities. Point number 4 is expanding the existing program known as DACA, which it stands for Deferred Action for Childhood Arrivals. Basically, DACA is a program that was announced 2 years ago to enable people who were brought here as children, who basically did not have any choice in the matter, did not intentionally break the law, but were brought here as children and have been here for more than 5 years and have no criminal record or indication of danger or threat to the U.S., to obtain a temporary permission to remain without threat of deportation. Again, not a green card, not permanent residency, but merely a temporary free pass so that they can work and live more or less normally for a period of 2 years. That program was limited to people who had entered the country at least 5 years earlier, meaning before June 15th of 2007, and it was not available to anyone who at that time had reached the age of 31. So that left a lot of people out who had been in the country the longest. Under the new expansion of the DACA program, the age limit is eliminated. So as long as a person entered the country when they were under the age of 16, had not had their 16th birthday, and they entered at least 5 years ago, and that all boils down to people who entered the country before January 1st of 2010 are eligible for the program. Under the new expanded version of DACA, the upper age limit has been eliminated so that people who arrived here a long time ago, more than 20 years perhaps, but did arrive when they were children, which technically in this case means before their 16th birthday, and have been present in the United States since January 1st, 2010. Those people will be eligible to apply for the benefits of the expanded DACA program. Again, they will also have to show that they have not committed any serious crimes, no felonies, no significant misdemeanors, and while one or two more or less insignificant misdemeanor convictions may be tolerated, that will be determined on a case-by-case basis. People with 3 or more minor misdemeanors likely will be denied in their applications. That's a tricky area, so that's something that needs much more careful scrutiny. An even larger and far-reaching part of the new policy change is point number 5, which is being called Deferred Action for Parental Accountability, or DAPA, D-A-P-A. This will affect people who have been in the United States continuously since January 1st, 2010, who do not currently have legal status, who do not have criminal records, but who have a child or children who are either permanent residents, green card holders, or are U.S. citizens. Those parents will also be eligible to apply for the benefits under this program. The benefits, again, primarily will be the right to remain lawfully in the United States without fear of deportation for 3 years, and then apply to renew at the end of that 3-year period. Under either the DACA or the DAPA, those folks will also be able to apply for employment authorization so that they can, again, be working lawfully, so that their hard work will not endanger their employers, and they will be able to pay honestly into the U.S. tax system, Social Security, and begin supporting themselves and helping the country. The 6th section of the new program expands the availability to apply for a provisional waiver of hardship. A hardship waiver currently is something that requires a person who will be subject to deportation or who has left the country and is now subject to a 10-year bar, will not be allowed to return to the U.S. for 10 years. Those people will be able to apply for a waiver so that they might be able to return sooner if they can show that their absence from the United States will cause extreme hardship to a U.S. citizen parent or a U.S. citizen spouse. Under the expanded program, under the expanded provisional waiver program, people who can show extreme hardship to a lawful permanent resident parent or a lawful permanent resident spouse will also be able to apply for this provisional waiver. And under the provisional system, they can apply for that before they leave the United States. Previously, they had to leave the U.S. first and then apply to see if the waiver would be available, which basically led to a lot of people not applying at all. Point number 7, revisions to the advanced parole system. This is another area that's a bit too complex for this video, but basically the executive branch, the Immigration Service, has the authority to parole or give permission to certain people to come into the U.S. if there are good reasons to do so, even when they don't have all of the correct documents. This will be used specifically, and already is being used, but this will clarify the rules and expand them somewhat to include the spouses and children of permanent residents who are members of the U.S. military or are planning and in the process of enlisting in the U.S. military. So basically, a benefit to U.S. servicemen who are permanent residents. They will be able to seek these advanced parole benefits for their families, so that when they're off defending our country, they don't have to be worried about their wife and kids being deported, or their husband and kids. The revisions to the parole program will also be adapted to facilitate the entry of entrepreneurs and business people who clearly will benefit the United States by being here in our country, using their genius, their talents, their skills to promote businesses and help grow the economy, rather than keeping those people out. The parameters under which those benefits would be extended have not been ironed out yet, but the business community stands to benefit greatly by not losing some very, very valuable talent. And finally, there will be clarification of what exactly advanced parole means and what it does. There is an advanced parole process right now for people who are here legally. They're in the process of getting a green card. They're not allowed to leave the United States unless they get permission in the form of an advanced parole. There is some misunderstanding, some disagreement within the Immigration Service and different agencies over what benefit a person gets when they get advanced parole, and what penalties may still apply to them if they leave and come back with advanced parole. The executive branch, the President, has directed that the Immigration Service, Department of Homeland Security, come out with some very clear guidelines so there is less ambiguity, so people know exactly what it is that they are applying for and what benefits they will receive. Number 8, promotion of naturalization, basically encouraging people who are already permanent residents to go ahead and take the next step and become U.S. citizens. And last of all, a variety of ways that the Immigration Service and its administration of visa applications and immigration petitions will be altered such that it provides more support for individuals and businesses that involve high-skilled workers, advanced technologies, and basically people with skills that our companies need so that our economy will stay competitive and move forward. That's a long list of many different areas. This program is very ambitious. It's also quite controversial in many circles. But again, the 3 areas that will probably have the widest ranging impact are the expansion of the existing DACA program, the addition of a new program called DAPA, or Deferred Action for Parents, and finally, revision of the provisional waiver eligibility. We will have more information as it becomes available. These programs, specifically the DACA and DAPA, the programs that will enable people to obtain a 3-year permission to be free of fear of deportation, those will not be available probably for about another 90 days, according to the Immigration Service, for the expanded DACA. And for the program that will benefit parents of U.S. citizen children, that may not be available for another 6 months. Again, the Immigration Service has been directed to prioritize these things. They may be able to put them out there sooner, but for the time being, that's the time frame that we're working with. Here at Gunderson-Denton, we are staying on top of the developments. We will be presenting community programs to get out there and help people to understand exactly what is available and what is not available. And of course, anybody that has serious issues, we have experienced attorneys in immigration law who can help you to look at your situation and make sure you don't unintentionally create more problems by filing an application when there may be something in your background that would actually create a greater risk.